Hello, everyone, and welcome back. Well, an issue normally kept within the walls of the state Supreme Court became a front burner and very public issue as justices battle over who should become the next Chief Justice. In the end, Justice Bernette Johnson was named to the top spot.
Alanah Odoms Hebert is joining us today. She's an attorney with the law office of Gauthier, Hotelling and Williams. She was one of the lead attorneys who represented Justice Bernette Johnson, and we are thrilled to have her here not only to discuss what happened in that case, but also to talk with her about those 9 constitutional amendments that will be on the November 6th ballot.
That's right. It's there's a lot to get into, and we're very happy to have you here with us. Let's talk about the case, though, with Justice Bernette Johnson, because you were there right on the front lines, and of course the case has been settled. What's the big takeaway from all that we saw play out with this case?
The big takeaway is that the Louisiana Supreme Court, in a 7-0 decision, voted Justice Johnson unanimously to the position of Chief Justice of the Louisiana Supreme Court. We're extremely pleased. Justice Johnson will be our first African-American female Chief Justice. It's a very proud time in our state's history and our nation's history.
Yeah, it is. And we were talking about this beforehand. John, this was such a divisive issue among attorneys.
It was divisive. It was contentious. And it's unfortunately a bit of a blemish on what should have been a smooth transition. Justice Bernette Johnson, who has served with distinction from serving on the Court of Appeals, before that on the trial bench, I believe, the first African-American jurist as Chief Justice on our Louisiana Supreme Court. And frankly, the resolution at the end was really very positive to have every voting justice on our Louisiana Supreme Court, a 7-0, you heard
unanimous decision.
Ms. Hebert say, unanimous decision, the decision in fact made by our Louisiana Supreme Court. Bobby Jindal, I think he woke up and smelled the coffee and said, you know what, we got to drop this appeal. That's what happened, right? They dropped the appeal in the in the Federal Court of Appeals. We're not going to appeal the decision by the federal judge recognizing the consent decree. Now, why don't you explain what that was? I want to make sure I'm getting my facts straight.
Absolutely. Lawyers for Justice Johnson have always espoused the fact that the federal consent decree governs the amount of time that should be considered for her total tenure on the court. So we've always argued that Justice Johnson's time counts because the federal law under the consent decree provided that she should have the same rights as any other justice. The state, on the other hand, argued that the Louisiana Supreme Court should interpret the Louisiana Constitution and should make that decision on their own. We were concerned that they would resolve the decision against Justice Johnson by essentially coming up with a different way of calculating her time. Very, very, very happily, they have decided to resolve that decision in the same way that Judge Morgan did in the U.S. District Court, and have also come to the same conclusion. So we're very happy about that.
If I may, Shauna, just the time on the bench determines who gets to be the next Chief Justice.
Right.
The longest in service, whoever has served the longest on the bench determines who gets to be the next Chief Justice. Since our current Chief Justice, Kitty Kimball, is going to retire at the end of this year or in January 2013, whoever has served the longest after her gets to be the next Chief Justice. Well, that would be Bernette Johnson, but because she first ascended to the Supreme Court by virtue of this consent decree as a result of the Voting Rights Act lawsuit under Chisholm, the case that we talked about before. Some justices on the Supreme Court thought that maybe they would go to the Supreme Court Chief Justice seat, well, Justice Victory, because Justice Victory was elected, not the result of a lawsuit, and there was concern that maybe the Supreme Court, if they decided they might look at some technicalities in our Supreme Court, there was that concern. I think the Supreme Court made a prudent decision to say, you know what, we are going to make this decision ourselves. This won't be decided by any federal court. This will be handled by us in-house. And I think that was the prudent, smart, and best decision, because the public outcry, goodness gracious, we talked about that regarding the Redmann, where I think 60-something African American judges and many others in the legal community, non-African American, attended the celebration mass elsewhere.
Right, yeah. And just before we move on to the constitutional amendments, just want to hear your perspective. How are things among the justices?
I would imagine that the transition of power in the halls of the Supreme Court takes place very similarly to the way the transition of power happens with our presidents and in every other area of government. We may fight with one another, we may disagree on the law or technicalities, but once we come to a conclusion on how the law should be resolved, we all move forward, and it's a successful and peaceful and happy transition. And so I think that the Supreme Court is united with the fact that Justice Johnson is going to be their new leader, and it's a very exciting time.
Yeah, okay.
And speaking as a practicing attorney, just like Alanah, I'm proud of the way our justices on the Supreme Court handle this. I'm proud of the way all parties involved finally realize that we've got to get along. Judges stand above the fray. They handle themselves with dignity, and I think it's the best way possible this could have been resolved. Shall we talk about amendments now?
Let's talk about amendments. We've got 9 constitutional amendments on the ballot. That is a lot. Alanah, help us.
It's a lot for folks to be thinking about. There are 9 amendments that will be on the ballot on November 6th, and we want them, all the voters, to be prepared and be armed with the information that they need. So I guess we can jump right into. First, I want to let everybody know that state constitutional amendments are really significant things that happen in this state. I like to think of the state constitution as a large oak tree, really powerful and strong. It's the fundamental law of the state. And the branches and the leaves are statutory law. And statutory law are what we send our legislators down to Baton Rouge to do, to fill in the details. So to put the leaves on those branches, and sometimes those leaves change. The leaves change in the fall, they change in spring and summer, and they change color. But that's what we really...
Sometimes we want to change the gardeners.
Absolutely right. Absolutely right. But I like to think of it in that kind of metaphor to let people know that these ballots that are on the up for a decision are very important and are something that the Constitution is really
the biggest ones first.
Meant to be
starting to run short on time.
A permanent thing. So the most important, one of the most important amendments that's gotten some considerable debate is Amendment Number 2.
Right.
And Amendment Number 2 deals with the Second Amendment right to bear arms, and you can remember it that way because the U.S. Constitution's Second Amendment is the right to bear arms. And what the amendment will do essentially is to provide even stronger protection for guns in this nation. We already have some of the strongest laws in the nation. This would make probably the Louisiana the strongest in terms of gun protection.
The toughest in the nation.
Toughest. And most important thing for folks to remember is there are already significant protections under state law for guns. This would actually remove language from the Constitution which allows the state to issue laws for concealed weapons.
Wow.
So that's something that's
a big deal.
It's a very big deal, and it would also subject any laws to strict scrutiny.
Now this is very complex. Talked to a constitutional law professor who said we have law students who study this for 2 years, and so here we are faced with this constitutional amendment. What is strict scrutiny?
Strict scrutiny is the highest review that any court can give to a law. It surpasses any other kind of review, and it makes it almost impossible to challenge or change a law.
Who would be behind such a request for a constitutional amendment like this? This is an NRA, National Rifle Association.
Yeah, it's absolutely an NRA.
In other words, they say anybody who wants to carry a gun concealed pretty much anywhere, don't mess with us. You can't just have the legislature pass a new law to modify it or restrict it, even if it makes sense. It's that kind of powerful.
They want to say that it is a fundamental right in Louisiana to carry a weapon, and what the constitutional language will also do is it says it broadens the rights to include the right to acquire, possess, carry, and transfer firearms. So it's not just the right to possess, it's the right to transfer, acquire, and carry. So it's a really big expansion of gun rights in the state.
Yeah. Okay. All right. Well, listen, we've quickly come up on the end of this segment, but when we come back, we are going to continue our conversation with attorney Alanah Odoms Hebert, and we are going to take your questions. So stay tuned. We'll be right back.